The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Wednesday, March 9th, 2016 are currently trading with gold at $1,252.65 an ounce, silver $15.29 an ounce, Texas crude $36.50 a barrel, and Bitcoin is currently sitting at about 411 U.S. currency. Today in history, the year 1961, the first animal safely returned from space after completing one full orbit around the Earth in Sputnik 9. A doggy named Chernushka, or Blackie, returned from the heavens. Today in history. In recent news, Tayrod Pugh, a U.S. Air Force veteran, was found guilty today of attempting to join the Islamic State. After a week-long trial at a Brooklyn federal court, a jury found Tayrod guilty of attempting to provide material support to ISIS and guilty of obstruction for destroying 4 e-storage drives after his detention in Turkey. Pugh is set to be sentenced in September. Pugh's defense lawyer is arguing that all he did was express repugnant views about the Islamic State on Facebook and watch dozens of the group's recruitment videos, and that he was only traveling to Turkey to find work, not to become a jihadist. However, prosecutors are presenting a letter he apparently drafted to his Egyptian wife, which was found on his laptop, in which he vowed to fight for Islam. When detained in Istanbul, he apparently had a black face mask, a map depicting Islamic State's strongholds in Syria, and a chart of the border crossings between Turkey and Syria. Pugh served as an avionics specialist in the Air Force from 1986 to 1990, and later worked as an Army contractor in Iraq from 2009 to 2010. Toyota recently showed off a new device that could dramatically assist the visually impaired to better navigate their surroundings. Called Project Blade, an informational device to bridge the gap between a cane or a guide dog. Toyota has been testing various prototypes of the wearable device with individuals from the visually impaired community for the past 3 years, and though the details of the project were released this week, no official timeline has been set for the release. The automaker plans incorporating mapping, object identification, and facial mapping technologies into Blade in the future. Doug Moore, manager of Partner Robotics at Toyota, told ABC that Toyota is thinking about quality of life for individuals and how to impact society. The Lone Star Lowdown is currently looking to fill some ad space. If you have a product or service you'd like to advertise with us, feel free to give me a call at 210-363-2257. This is Rick Rohde with your Lowdown for March 9th, 2016.
Somebody been shot, somebody's been abused, somebody blew up a building, somebody stole a car, somebody got away, somebody didn't get too far, yeah, they didn't get too far.
Grandpappy told my pappy back in my day, son, a man had to answer for the wicked that he done. Take all the rope in Texas, find a tall oak tree, round up all of them bad boys, hang them high in the street. For all the people to see.
That justice is the one thing you should always find. You gotta saddle up your boys, you gotta draw a hard line.
When the gunsmoke settles, we'll sing a victory tune, and we'll all meet back at the local saloon.
We'll raise up our glasses against evil forces, singing whiskey for my men, beer for my horses.
All right, folks, good evening. This is the Monday Night Rule of Law radio show. It is March 21st, 2016. If we just keep rolling the way we're rolling, that edge of that cliff is coming at us at a very rapid pace, don't you think? Just FYI, the phone lines are open if you wish to call in and start getting on the board. 512-646-1984 is the call-in number. I just want to go over something very briefly this evening while we're waiting on the caller board to fill up, and that is understanding where the justice system in America first went wrong. And actually, it's very simple to identify where it first went wrong. If we look at how the constitutional principles are set up, where the people created the constitutions, just for the sake of argument, let's go with that thought, that the people created them, therefore we are superior to them. And we use those constitutions to then create something that is to operate beneath that Constitution, and therefore, as an instrument created by us, beneath us, then they are subject to whatever is in it. And in it, we said, these are your delegated powers, and these are our rights that are forever removed from your ability to do any harm to. You can't legislate against them. You can't opinionate against them. You can't exercise authority against them. Remember, what are the general powers of the three departments of government? The legislature's general power is to create law. The judicial branch, their general power is to interpret the law. And the executive's power is to enforce the law. It's that simple. So if those are their general powers, and the Bill of Rights that we have is forever accepted from those general powers, then anything they do in violation of the Bill of Rights is automatically null and void. Now, this would include how they handle the delegated powers we gave them. Here is where our judiciary and the attorneys that populate it and the judges that were created from these attorneys have run afoul of common sense and common application of constitutional principles. If we have reserved our Bill of Rights, which none of us have the authority to harm anybody else's rights, even without a Bill of Rights, we certainly cannot delegate to our lower-level servants the ability to harm somebody else's rights. Okay, we just can't delegate that to them. We know this. So that being said, what we're dealing with here is they take the delegated powers, and this is something the Supreme Court has done in every state, and the United States Supreme Court has done numerous times, and that is to do things where they expand government power at the expense of the Bill of Rights. And what they do is they say that here we have these delegated powers. So in order to exercise and do our duties under these delegated powers, we have to adversely affect your rights in order to do what these delegated powers told us to do. That interpretation is absolutely incorrect. The proper way to interpret the delegated powers is this. If you are attempting to exercise a delegated power in a way that conflicts with a protected right, then you are exercising the delegated power wrong, not the other way around. The delegated power cannot supersede the individual rights because that right is inherent in the people as individuals, which we cannot delegate away to you guys in government, in which case you cannot use that delegated power to harm a superior right. Now, how hard is that for you to understand? If I gave you the power, through power of attorney, let's say, to sell my car because I was going to be out of town, you cannot turn around and argue that in order to properly exercise that power to sell my car, which I keep locked in my garage, that delegated power to sell that car allows you to sell the house because the car is in the garage. Yet that is exactly what the government and the courts have attempted to do with the delegated powers. They have tried to say that you gave us these duties and we have to infringe upon your rights to do these duties. Wrong. That means you are doing something with those delegated powers that you're forbidden to do. Because you have a conflict of interpretation forever removed from the general powers of government. Right there says you cannot take that delegated power and affect that right with it. Can't do it. This, ladies and gentlemen, is the problem with allowing attorneys to control every aspect of government. And that's what we've allowed to happen in this country. This is why this country is in such a big mess, because we have allowed a constitutional violation to grow like a cancer in the midst of America. And that is an aristocracy in the attorney class. They have gotten all of the jobs that control all parts of government and made it where they're the only ones that can occupy them. And through that occupation, have colluded through the individual departments of government to deprive us of every constitutional protection and every reservation of rights that we have to limit what they can do. Now, if you doubt that, it's a very easy thing for you to verify that I'm right. Take any situation you desire in America, and I guarantee you, you will be able to trace it back to an attorney. Every problem we have is the result of some law. Every law we have was created by some attorney. Now, some legislator may have sponsored it that isn't an attorney, though we have very few of those left anymore these days. But even so, everything goes through attorneys before it gets approved for anything. It gets reworded, it gets reworked, it gets resubmitted. Attorneys are doing all of it. Attorneys have made it where they are the only ones that can occupy the judicial department of government when it comes to courts of record. Did you know that? Here in Texas, you cannot be a judge, an elected judge. This is an elected constitutional office. And the attorneys that have control of the legislature have passed laws to ensure that no one except another attorney can sit as an elected judge in these courts. Now, how's that possible? How is it a constitutional office if the only way to get it is through statute, and the statute has been limited to a particular class of individuals who have proven themselves to be inept, corrupt, immoral, and completely statist in what they do? Everything can be traced back to this. Everything. This is exactly the reason why the original 13th Amendment to the federal Constitution was written, to prevent where we are right now. That original 13th Amendment made it very clear that no one with a title of nobility could be a government official. They could not serve in public office. Now, everybody wants to say that esquire is a title of nobility. I'm not buying into that. But when they start giving themselves of titles like Your Honor and so on and so forth, and then making demands that you honor them in their hubris when they walk into a courtroom, somehow or other, these people think they're above us instead of working for us. I got news for you, ladies and gentlemen. There is no requirement for you to stand for a judge when they enter or exit a courtroom. I don't care what a bailiff tells you or threatens you with. Now, in my Christian upbringing, I've been taught we don't pay homage to men. We don't do it. But that is what these judges coming into and out of these courtrooms are expecting you to do. Pay homage to them. Rise up. Honor us for walking in here so we can steal from you under the guise of some authority that you didn't really give me, but I'm going to exercise anyway. That's what we're talking about here. Every problem, and I mean every problem, short of gross stupidity, can be traced back to a lawyer who created a law that was meant to do nothing more than provide income for attorneys. Every malum prohibitum law that we have that's being used against the public unconstitutionally and illegally is not there for the public health and welfare. It's there for revenue generation. It's there to create a conflict instead of resolve them. It is there to ensure that in order to navigate the waters of the legal system, you have to hire an attorney. And when you won't hire an attorney, then you are fed to the sharks in that system. Even if you know what you're doing, even if you know how to do it, you will have an uphill battle to win, even if you're right. Because they don't like having to admit that they are more incompetent and inept than the general public is in many ways, especially when it comes to understanding individual rights or caring about individual rights. So, folks, I want you to keep that in mind. Our problem with society starts with attorneys, and it ends with attorneys. We need to get out from under this aristocracy and back into a society of free people freely associating. We'll be right back. Y'all hang on.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Look what we got. We asked the question. I wonder what they're hiding. Don't have the answer. They're not abiding. We asked the question. Look what we got. And they don't have the answer.
All right, folks, we are back. This is Rule of Law Radio. All right, we have a caller that's up on the board getting screened right now, so we will wait until they get back. Folks, if you're up on the caller board just to listen in, please understand that that is not a listener line. That is for the call-in numbers. I'm sorry, but we don't have an actual listener line. If you want to listen to the show and you're not local, where you can tune it in on the actual radio, please use a computer or your cell phone internet connection or something of that sort and stream it over the internet. Streams are what we need anyway, as much as possible, because that's what big studios and financiers and supporters and things like that look for, is how popular an internet show is, and they can only do that if we can show them stream information. So if you can, please listen to us online as much and as often as possible. All right, that being said, it looks like this caller is Neelan. I don't know where he's from. Neelan, what can we do for you? Where are you calling from?
North Carolina, sir.
North Carolina. All right, what do you got?
Sir. How are you, Eddie? I've been listening to you for a while. I've been actually going over and over and over your transportation script and everything. I didn't get a chance to get to it before my last endeavor with the police in Catawba County. I was pulled over for a routine traffic stop, a regular traffic checkpoint or a license checkpoint. And I've got in my back window of my vehicle, in the back of my conveyance, my personal property, I've got in the window, it says not for hire. Clearly, it's right there in black and white.
Okay.
The police stopped me. They asked me for my driver's license. I said, "Well, I'm not operating under commerce. I'm not doing anything that requires me to have a license." So he asked me to pull over into their little secondary, whatever, and I'm complying with him. I got off the road, got out of the way of traffic, and pulled off to the side of the road and did what you said. Just let my window down 2 inches or so. And I had just got done with a 14-hour shift at work. Okay. I'm a demolition carpenter. I do remodeling and that kind of stuff.
I thought you were going to tell me you got to blow crap up, but okay.
No, I don't know. I'm thinking about it though. No, I'm kidding. I can't say that out loud. That's not good. But anyway, no, they escalated the stop like you were talking about. They couldn't get anything from me because I invoked my rights. I told them that I'm not going to give you guys anything that's going to incriminate me. And after I told them that I'm not operating in commerce, they kept on trying and pushing and pushing and pushing. They were shining their flashlights all in the back of my van. I had a bunch of stuff in my van that was going to a scrapyard the following day, so I could supplement my income. I had a bag full of beer cans and soda cans, and they started talking about, even though I only had that one window open, they started talking about, well, we smell alcohol. And their reason for breaking my window eventually, it took them about, I'm going to say probably 45 minutes into the stop of detaining me, after they couldn't get anything else from me, they started talking about, they could smell the alcohol. They were looking at the beer can labels right through the bag. You could see right through the bag. It was a clear plastic bag. But they started talking about they could smell beer, blah, 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 and my eyes were looking glossy. So that was their probable cause, okay? No warrants were issued. They didn't have any warrants or anything like that. There was no crime committed, and nobody was harmed in this process except for me. They busted my window, dragged me out of my van, through the glass, and they locked me up for 3 months, thinking that they're gonna change my mind about how these things are supposed to work. All right, now I've been watching Carl Miller.
What do you mean they locked you up for 3 months?
3 months, man.
Well, whoa. Okay, wait. We're missing something here. The cops arrested you, correct?
Yep.
You went to trial, correct?
No. It's still open. That case is still open.
Then how did you spend 3 months in jail?
That's right. Good point. My point exactly. Due process violation all the way around, man. You're exactly right. And, I could really use some help with this because I'm a flat broke joker right now. I've been this driver's license issue has been going on with me for 15 years. I turned myself in twice over the same charge that they're claiming is still out there, outstanding. That is what is holding up my driver's privileges. But you know what? Since they have revoked me, my right reverts back to the common law, and I know that I have the...
Okay, wait. We're not in a legal debate here. Do you have a question about any of this?
Oh, yeah.
Okay, what's the question?
Okay, right. In the position that I'm in right now, how do I go about? Okay, I got this case is still open. The driving while impaired. Here's what they did.
Okay, wait a minute. What evidence did they accumulate to prove driving while impaired?
Zero. I gave them no roadside test, no urine, no blood, and when I went in front of the magistrate, get this, I went in front of the magistrate, they had me...
How long before you went in front of the magistrate from the time they pulled you out of your car?
It's probably about 2.5 hours. Okay, so I go in front of the magistrate, and hopefully there was cameras on, and I'm trying to get those records brought into the record. I want that there. They had me they tried to get me to sign an implied consent form, okay? And as I was doing that, I wrote UD 1-207 without prejudice on the first form.
What is UD 1-207?
Under duress 1-207, meaning I'm not signing this because I agree to what's in the contents of this document, but I'm only doing it because you guys are making me, okay? Still invoking my rights.
You realize 1-207 is now 1-308, right?
It's both. I mean, as far as Carl Miller told me the 207, but anyway, 207, 308, I think they go pretty much hand in hand. Universal Code.
No, they've changed it, is my point. They don't go hand in hand. 207 became 308.
Oh, okay. Okay, but anyway, this was my understanding, and so with...
Hello? And he drops. Okay. No, folks, that was not me. Honest to goodness, I didn't cut him off. He just disconnected. Okay, well, I got 2.5 minutes. So while we're waiting on him to reconnect, I'm going to take Jeff in Mississippi. Jeff, what do you got? I got 2.5 minutes, which means I can give you 2.
Hey, Eddie, thanks for having me on the show.
Yes, sir.
And I have got a form. It's called a conference form. They want to have a conference, and they want parties to agree to Rule 26 for my Title 42 federal suit. So the opposing attorney has sent me a form in which both parties fill out or sign, and it's a scheduling form. And so far, the form has nothing but dates on it. There doesn't seem to be anything suspicious. But he asked me to sign it over email using italics and then just to shoot it back to him. What is your experience on that?
I don't know. What is Rule 26?
Rule 26 is the scheduling orders for people to have conferences and to get all their discoveries and stuff, to talk about a timetable. And it's mandatory, or at least it is in my case. So I have to get with the attorney and have a conference, which is a telephone conference.
Well, that's generally the way they do it. The federal courts, they hate to adjudicate cases if they can make you resolve it before ever getting it to the court. Mm-hmm. It's basically a bunch of lazy, fat old men and or women that don't want to do their job if y'all are going to come in there and argue about stuff. That's the whole point, right? Mm-hmm. So, yeah, they pretty much force everyone down this path to minimize the number of cases that aren't settled before they get to court.
Well, this form is more on a timetable. Trial is set for December. Do parties agree to have all discovery in by 90 days before, and by May 14th this is done, and June 12th this is done?
Right.
I will sign that if it's okay, and I'll send it back to him.
That's just it. Have you put in discovery and they've replied to it? Are you going to do you think you can get the discovery by that time frame, and so on and so forth? Hang on, and we'll finish this on the other side of this break, okay?
Okay.
All right, folks, 512-646-1984.
Here in the U.S., you can name your child pretty much anything you want, but creative naming and weird spelling won't fly in other parts of the world. I'm Dr. Catherine Albrecht, and I'll be back in just a moment with some surprising laws about baby names.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Is it a girl or a boy? In Denmark and Germany, you should be able to tell by the baby's name. It's the law. For example, the name Matti is verboten in Germany because it could cause gender confusion. Several countries won't allow names considered harmful to a child's self-image. The names Adolf Hitler and Satan are banned in New Zealand, which might be understandable. But fans of the king of rock and roll might wonder why the name Elvis has been rejected in Sweden. What's not surprising is that Chinese baby naming laws reflect the country's control agenda. Parents must give newborns names that can be easily scanned by a computer for the country's national ID card program. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Live Free Speech Radio, LogosRadioNetwork.com.
Yeah, I got a warrant, and I'm gonna serve them to the head government, them, prosecute them. Okay. What's that? Citizens arrest for Mr. Bush. Citizens arrest for dictating. Well, I need our prosecutor to come.
All right, folks, we are back. This is Rule of Law Radio, and we are talking with Jeff in Mississippi. Okay, yeah, as I was saying, if you are sure that you can get all of your discovery and everything met by that deadline, then go ahead and sign it if that's all that they're telling you it's for, just to get deadlines established that everyone's supposed to meet.
Okay, and I can sign it over the email and send it back to them?
Whatever criteria they said you could sign it by. I don't know whether that's acceptable or not. If they told you it was, then I would presume so. If you don't know, then I would call and ask or look.
Okay, that's fine. Second thing is when they responded to my complaint with a motion 12B6,
right,
to dismiss.
Right.
And in one of the paragraphs, the attorney completely lies through his teeth.
Then you need, in your response, you need to address that to the judge and ask for sanctions for a blatant misrepresentation of the law and the facts to the court with the intent to perpetrate fraud upon the court and deny due process to you as the plaintiff.
Do I do this when I'm in front of the judge?
You do this in your answer. You should have done this in your answer.
Okay, well, I already answered, and what I did was I said in the answer that the attorney made a fraudulent statement.
But did you define what that means?
Yes, I said paragraph 3, blah, blah, blah.
And you spelled out why it was false?
Yes.
Okay, then you did what I said. You addressed it in your answer, but you want to raise it verbally on the record in open court as well.
That we need sanctions against this guy right now.
You can say, Judge, I would like to move the court for sanctions against the prosecution relating to the item in my response where I detailed that he perpetrated a knowing and willful fraudulent statement to this court regarding the facts and issues in this paragraph of this motion, blah, blah, blah.
Okay. Got it. Okay.
See, this is something they won't do to each other. You have the benefit of not being in that club.
True. Okay.
Okay, that's one of the reasons why me and attorneys don't see eye to eye, because I have absolutely no problem with peeing in their pool.
Uh-huh. That is nice. Okay, well, those are the only two questions. I certainly appreciate it, and I will get right on that.
All right, Jeff, good luck.
Okay, thank you.
All right, bye-bye. All right, now, let's see if we can keep Nealon on the line here again. Nealon, are you back?
Yes, sir.
All right.
It's Rick, yes, sir.
Hey, Rick, okay, I'm sorry, Rick. I don't know how they've got this arranged up on the caller board, so.
That's all good. Not a problem. Hey, listen, I've got a big question here for you.
Okay.
Like I said, I did that 3 months in jail. Okay. I've got a public pretender that got me out on an unsecured bond. Okay, and I'm awaiting my trial. It's supposed to start on the 11th of this month in Catawba County, North Carolina. And what I'm wanting to know is this guy's acting like he doesn't understand anything about this transportation code. You know, he doesn't understand a thing about none of the stuff that I'm talking about to him.
And he may not, but then again, he may also be playing willfully ignorant.
Right. Okay. All right. So what do I do if this guy flubs my case? I mean, if he flubs my case,
well, you sue him for malpractice is what you do, but you better be able to prove that he did that. See, it's one thing to know the truth. It's another thing to be able to prove it on the record in court.
And it's going to be hard to do that because the guy's he's still playing ignorant.
Whoa. I wasn't talking about him. I was talking about you. If he screws this up, you have to sue him for malpractice. But in order to win that malpractice, you have to prove that he could have known and should have known that the charges against you were fraudulent because you were not engaging in an activity which required you to comply with the law surrounding that activity.
I told him to watch your video.
Whoa.
Yeah.
My video is not admissible evidence of South Carolina law. Does that not? No, it's not.
Okay.
How would my video on Texas Transportation's code be admissible evidence on South Carolina's code?
No, it's not North Carolina, but anyway.
Well, North Carolina, any Carolina.
I was just trying to...
BFE Carolina. It's not admissible evidence for that. You still have to go to the law of your state, and I say that very clearly in the video. You will find that most of the state laws will be very similar. But you need to find out which ones match up with which facts. And I even did an article on my blog about how to do that.
Right. I'm not trying to look. I'm not shooting the messenger.
No. I know that. I'm just trying to make it clear to folks out there how this works. I've got too many people calling me and say, I saw your video and I went and did this. Well, what state do you live in? Oh, I'm in Maine. What the hell are you doing this in Maine for if you haven't studied any of the Maine laws on the subject? See, that's the problem.
Okay.
Everybody treats my video like I've given them a golden key instead of simple information to help them find their own key.
Their own information, yeah. Yeah, they got to get their own key. You're right. Yes, absolutely. Okay, I'm looking for the keys.
Okay, on my blog site, Tao of Law, TAOOFLAW.wordpress.com, I did an article on how to research the actual bill, the session bill passed by the legislature, to identify what the subject matter is that it dealt with. So you will know what the subject matter, the statutory scheme, is limited to. The statutes cannot supersede the underlying law. They're not the law.
Right, exactly. And that's just like the Supreme Court rulings are just under the Constitution, correct? I mean, but they support the Constitution, but they cannot stretch the instrument beyond its means.
Well, they don't stretch it. They rip it to shreds a lot of times.
Yeah, I get you.
Okay, but here's the problem. Everybody acts like the federal Constitution is the only Constitution, too, and it's not.
We've got a state Constitution.
So when the Supreme Court says the federal Constitution doesn't offer a protection for something to the people, that does not mean that their individual state Constitution does not.
Doesn't? Right. We're still under the common law here in North Carolina.
We're under the common law in every state. The difference is what they're calling common law in the states.
Right. Okay. And so I have to read up on what that means. Okay. All right. So with me being locked up for that 3 months, I mean, do you see anything wrong with what they did to me on that? I mean, with that stop, that routine driver's license checkpoint where I invoked my rights and said, I'm not going to give you guys any documents, nothing that's going to incriminate myself. They pushed me to the point where they busted my window and dragged me out of my car. And then they got my ID from me and came up with some charges that were 15 years old, some misdemeanor shit.
Careful with the language.
I'm sorry. Yeah.
Deborah will ban you. You keep doing that.
I'm sorry about
that. In any case, you're still talking about two different things here. You're talking about defending yourself from their allegations versus suing them for interfering with your rights under false allegations. They're two separate issues here.
Right. I've got that in the works, though. The suit is coming soon after this case is dismissed.
Okay, that's well and good if you know what the suit is you're bringing. Okay? Everybody wants to go and argue right to travel in this. This was never about a right to travel.
Process, correct? I've got liberty.
Whoa, wait a minute. You've got a completely different issue. Your issue is the 3-month incarceration without ever being adjudicated guilty of anything. Okay? The thing is, it would also depend upon what level of offenses they're trying to hit you with as to whether or not they're going to get away with that.
Mm-hmm.
If these were Class C fine-onlys in North Carolina, then incarceration was never a valid part of the punishment. If they were any other level of misdemeanor where they could incarcerate you, then that becomes another issue you need to look at. But still, without...
Attorney, explain that a little further, please. I mean, Eddie, I don't mean to sound like a dummy, but I mean, I am a dummy. You know what I mean when it comes to this. So if you can clear up what you're saying, I mean, put it in simple layman's terms, because that's what I am.
I thought I was doing that, but let's try this again. If they're charging you with a felony... Wait a minute. If they're charging you with a felony, holding you in jail for 3 months to get ready for prosecuting you on that is not going to be as big a deal for you to claim a rights violation as it would be if this was a Class C fine only for which they couldn't throw you in jail even if you're guilty.
Okay, now, with it being the...
All right, hold on, Richard. Rick, I got to take a break here. We'll get to this on the other side.
Sure.
All right, folks, 512-646-1984. We'll be right back. All right, folks, we are back. This is Rule of Law Radio. Call-in number 512-646-1984. And we are still talking with Rick in North Carolina. All right, Rick, go ahead.
All right, now, on the criminal side, from the criminal aspect of this, I should not settle for any less than a dismissal, and in fact, shouldn't I be able to get from the courts a suppression of the evidence based?
Well, I don't know what all the evidence is, and I haven't seen what transpired at the time, so I can't answer that. You should try to get it done, of course, but whether or not you should get it or will get it, that I can't answer.
Right. Okay. He said he's going to try to do that based on whether they gave notification, based on the length of time they had me detained, prior to the arrest and that type of thing. But like I said, when an officer approached me, I've got not for hire right on the back of my van. Right, that sits there right there in plain sight. And then I continued to tell him that I'm not involved in commerce or transportation, any of those regulable activities, blah, blah, blah. But they wanted to keep pressing. And, when they did that, they did what you said, and they escalated it to something more severe than just the traffic stop. And then the next thing you know, they're trying to tell me that I impeded police investigation, blah, blah, blah. Threw a ticket at me for that. I've got like 5 different charges looking at me, you know what I mean, out of that one stop. Failure to register, failure to have an inspection, failure to have insurance, blah, 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 all this stuff. No accident involved, nothing. You know what I mean? And like I said, never tested. I didn't do a urine sample, didn't do a roadside, what do they call it, sobriety test, none of that stuff. And then when I went to sign the implied consent and signed under duress, regardless whether I got the numbers right or not, I signed it under duress, okay? I didn't know that they had changed it to the 308, but now that I do, I'll keep that in mind. But I did clearly sign it under duress, okay? And the cop just ripped it right out of my hand, in front of the magistrate, no less, right there in front of the magistrate. And then I got locked up, and I did the 3 months in jail, and then my court-appointed...
Okay, I still haven't heard how you wound up in jail.
How?
Without ever going to court and having a trial, how you wound up in jail for 3 months.
That's what they did to me. That's what they did.
Okay.
And I'm still awaiting the trial. Still waiting. So you tell me what I'm supposed to do. What should I do? I mean, I don't know how they got away with it, or if they did. I don't think they did get away with it.
Did they set a bond that you had to pay to get out?
Yes.
And you didn't pay it, or you didn't get a bail bondsman to pay it?
Couldn't pay it. And they had too many FTAs out on me because of those previous charges that they came up with. I thought I had answered all my charges in North Carolina, but they had charges from 15 years ago. Just stupid misdemeanor stuff. You know what I mean? And but they had me held at that jail, that particular jail where they arrested me. They had me held there for that 3-month period of time on those charges, and not until those charges were placed under what they call it, an unsecured bond, was I able to go take care of the other charges that were from 15 years ago that they ended up dismissing one after another. You know what I mean?
Okay.
So I pretty much went through my whole whatever I did 15 years ago all over again, and they tracked me from one county to the next, and they dragged me through there like a cow with a nose ring, you know what I'm saying, and just pulled me through the crud. And but anyway, the thing is, they did not release me from them charges. I was not released from them charges until 3 months into my stay in their nice hotel. I was there for 3 months, and then my attorney finally talked the judge into letting me go for what do they call it?
Time served.
Secured bond.
Yeah, unsecured bond. Okay, I thought they let you out on time served, but okay. Either way, this attorney's not going to help you with the civil lawsuit side of that. He might can recommend an attorney that will do it on contingency, whatever, or you need to learn to do it yourself, which you'll need something like the jurisdictionary course to do.
I'm trying to get the pro se thing together right now myself. But I need to know which angle to come at. Like the due process.
Richard.
Yes.
You need to get something like jurisdictionary that will teach you how to properly do a lawsuit, and then you need to start researching cases on filing Title 42 lawsuits in the federal court.
Title 42?
Yes.
Okay. All right. Well, I'm in the Middle District. The Middle District, it's going to be federal court in the Middle District of North Carolina. They give me a pro se packet, and I'm trying to file, what do they call that?
It doesn't matter what they give you. You still have the responsibility to file everything properly, or they will throw it out, especially if you attempt to go in there indigent.
Okay. Yes. And now, what did you call that just now? It was what? Something 42 what?
It's a Title 42 lawsuit. Title 42, 1983 or 84 or anywhere up there, depending upon what your claims are.
Okay. All right. And so how do I determine my claims?
Well, again, that is exactly what you need to be reading up on, what your causes of actions are in a Title 42 lawsuit and how to state them.
Okay.
You need to go to a law library or some library that's got law books and read up on the subject if you're going to do this yourself.
I've been into that 16th exam jurisprudence.
Okay, wait. American jurisprudence is an encyclopedia of law. It is not the law. It is not a law book. Okay. It is an encyclopedia of court opinions on given subjects.
Okay.
It gives synopsises of those court opinions. It's an encyclopedia, not a law book.
Okay. Title 42.
Yeah.
That's what that's what I'll find out.
Title 42 civil rights lawsuit.
Civil rights?
Yes.
Okay. All right. I thought we weren't talking about civil rights. I'm not a slave.
If you want to split those hairs and have nothing better to do,
I don't. No. I just heard you say it on your last show.
No. Whoa. We're talking about two different things. I am telling you what the proper vernacular is for these types of suits so you can research them.
Okay.
I'm not giving you a label. I am telling you what the type of suit is called. If you want to be able to find it in the law library, that might be handy, don't you think?
Yep. You're absolutely right. Absolutely. Dude, I appreciate you, man. You're awesome, man. You're awesome.
Well, I appreciate that.
You're the best, bro. Yes, sir. Absolutely, man. I'm telling you. I love you. I love Alex Jones. I love Carl Miller. You guys are a bomb. And I'm going to tell you something. Yeah, what is it? 42. That's what I got to look up, and I'll find out. I'll get my answers from that.
All right.
But anyway, I'm trying to get myself a rally to rally for any drivers that have had their licenses taken away, and we're going to.
Well, you can't rally for anybody but you, so concentrate on you.
Right on. You're right.
Okay?
All right, brother. All right. God bless you, man.
You too, Rick. Good luck.
All right, man. God bless you. I'll see you later, man.
All right. Bye-bye.
All right. Thank you.
Yep. All right. Now we're going to go to Ted in Washington. Ted, I got 3.5 minutes to break. I can give you 3, and then we'll pick you up after that if we need to.
Excellent, Eddie. Thank you, sir. How is the call quality coming through?
Other than sounding a little bit like you're talking from the bottom of a can, fine.
Okay. Hopefully the reception improves a little bit. How's this?
Well, like I say, I can hear you fine. It's just got a tinny timbre to it when you speak.
Okay. Sorry about that. It's the best I can do.
No, that's okay. Go ahead.
Okay. Excellent. Thank you. I need some help with instructions and paperwork to file a public information request or a Freedom of Information Act paperwork.
Wait, you want to know how to do that?
Yes, I need to know how to do that, and where can I acquire the paperwork from?
You're in Washington, right?
Yes.
Okay. Does Washington have a Freedom of Information Act, or they have a Public Information Act, or an Open Records Act? What is it under the laws of Washington? You have to remember, FOIA is a federal government program, Freedom of Information Act. Some states have state FOIAs, but they don't call them FOIAs. They might, but you need to figure out what they are in your state. For instance, here in Texas, they can't figure out what name they want to give it. They used to be the Texas Open Records Act. Then it became the Open Records Act. Then it became the Public Information Act. They can't make up their damn minds. So you need to figure out what it actually is, because that's where you're going to find the statutes that tell you how to do it and what everyone has to comply with.
Okay, so I need to do some research and study. Okay.
Now, again, which one you're going to use, the federal or the state, will also depend upon who you're requesting the information from. If you're going to a federal agency, then you use a FOIA. If you're going to a state agency, you use the state laws for that.
Okay, this would be the Washington State Troopers.
Okay, then you'll use the state laws unless you're asking for information on a federal program implemented, managed, or maintained, or executed by that state agency. Then you should be able to do it with either or.
I see. Okay, because I do have some details as to why I'm going about it this way. And
okay, well, if you'll hang on just a minute, I'll be happy to cover those with you on the other side of the break. All right, so if you'll hang on, we'll cover that when we get back, okay?
All right.
All right, folks, this is the Monday Night Rule of Law radio show with your host, Eddie Craig. Call-in number is 512-646-1984. So if you want to call in with an issue or a question or even just a commentary and let us know what you think of the show or any of the shows, that'll be fine. And do remember that we're still trying to get the fundraiser completed. I don't know how well Deborah's doing on that. But please just check the website, logosradionetwork.com, and we'll see what we can see there. But in the meantime, we're going to take a break. We'll be right back.
It's all according to the will of the Almighty. I read his book and it says he cares not for the unsightly. These warmongers come by that term rightly. I won't pay for the war with my body. Ain't gonna pay for the car with
right, folks, we are back. This is Rule of Law Radio, and we are talking to Ted in Washington. All right, Ted, go ahead.
All righty. So the reason I want to get this public records request is I'm trying to obtain information about the state troopers' vehicles themselves. The reason for that is I got pulled over for tinted windows while driving engaged in commerce, and they themselves have tint on their fleet cars too. So I'm wondering if I could use that as leverage in my situation.
Not if the statute grants a special exception for them, which it very well probably does.
Okay. Ouch.
But now you need to verify that. But now also be aware of this. Certain information relating to what they would consider, it's not classified, but they treat it as if it is. So it's been accepted from Public Information Acts, and you may be able only to obtain it through discovery. But that type of information or discovery will not help you if the law gives them a specific exception for it.
I understand.
So you need to check the statute to see if the window tinting statutes or anything relating to the agency itself grants them that exception.
Okay. So more research.
Yes.
All right. It'll be fun stuff. I did submit a motion to dismiss, and I also submitted a Brady request. But on that Brady request, I did not ask information about their fleet cars themselves. It was just the front and back of the ticket and names of witnesses they're going to rely on at the hearing.
Okay. Well, you may have already shot yourself in the foot about getting any of that through discovery if you've already filed a motion for discovery. They're not going to let you keep filing discovery over and over again, so you need to be real careful about that.
Okay, I see. I was hoping that this public info request can be slightly different than the Brady because...
Well, the thing about it is discovery is more powerful than public information request, and here's why. Public information requests are limited to official records. Okay? Now, those records include things like policies, procedure manuals, and things of that nature, but they are limited to records. Whereas discovery can be virtually anything relevant to a case that is in the possession of some other party or person that is relevant to the case. And you need to prove one side or the other of it.
Gotcha. So at this point, you're saying that the odds are against me? Because the facts are...
No, I didn't say that at all because I don't know what all the facts are. What I'm saying is that you are jumping the gun without enough information. You're looking to discover information that without knowing what the statute does or does not accept may or may not do you any good. Thus, you're wasting time and increasing your expense to do it. You see what I'm saying? I'm not saying it's a bad thing. If there's an exception, then it's pointless. If there isn't, then it might be something to rely on.
What would be a good starting point that you recommend for me to do all this research in?
Well, what all research are we talking about here? Because the only thing I've heard you mention is window tint.
Right, the application as to who it applies to.
The window tint?
I'm using this. Yeah, I'm going to start using...
Okay, you said you were stopped engaging in commerce, right?
Correct.
Okay. So where are we going to come up with an argument that a commercial statute doesn't apply?
No, I wasn't saying that. I was just trying to find the proper use of my energies to start researching this.
Well, again, you need to look at what the window tint statute says, and then you need to see if it matches the underlying law. Remember, the statute is not the law. The statute is an interpretation of the legislative act, which is the law.
I do remember you saying that on previous shows, yes.
So, when you look at the statute, you need to find out what legislative session and bill number that statute came from. Then you need to go and pull up that bill, whether it be on the legislature's own website, a law library that's got the journals, whatever, but you get a copy of that bill, and you, at the very top in the title or caption, it'll tell you what the subject matter is, what it relates to, and what all the statutes, therefore, must relate to. Then you look at the statute in question within the bill. Now, remember this also. You don't stay with the bill that created the statute you're looking at, okay? Because all that is a legislative rubber stamp. You have to go back to the original underlying law, which may be several statutory revisions backwards. For instance, here in Texas, do you know what laws all the current statutes are based on?
I do not.
The actual laws are the 1925 session laws.
Wow.
Everything since then has been an amendment to the existing statutory scheme.
Okay. So amendment to the laws. Okay. Excellent, sir.
Okay.
All righty, lots of research coming up. This is very inquisitive for me, so I really appreciate it.
Well, wish you luck.
All right. Thank you, Eddie.
You're welcome. Bye-bye. All right. Now, let's see. We have Donald. Donald, I don't know where you're at, but what can we do for you?
Fort Worth, Texas.
You're in Fort Worth, Texas, okay?
Got a document I had forwarded you via email, Municipal Court Automated Red Light Enforcement Appeals.
Yes, sir.
The hearing officer told me I had no defense. And
the hearing officer in this case was some police officer in that municipal police department, correct?
That's correct.
Okay.
And he shared with me because I was bound by signing my license, my driver's license. I was bound by the transportation code of 707, or transportation law, 707.013.
Well, here's the problem. First and foremost, that's a legal conclusion, which a moron in blue is not qualified or empowered to make. Second problem, this so-called appeals process you wrote me about is not an appeal. You know why? Because you don't get a jury. The only person you're going to get to see for your appeal is a judge in that same municipality. In other words, the city is your judge, jury, and executioner in this case, which means there is no judicial review of the facts of the case. Everything in your case is administrative and therefore constitutes nothing more than an unconstitutional and illegal bill of pains and penalties.
So there's no jurisdiction.
Well, the thing about it is the statute, even if the statute were valid, and it's not, the statute only authorizes them to file a civil lawsuit to get the $75. Okay? They have to sue you. That's what the statute specifically says they can do. It is a civil penalty for which they must file suit. They didn't file suit. Then they turn around and say that the only way that you can contest what they do is to pay them first. That's also illegal. Okay?
Uh-huh.
So right there, they have several problems with this. The question is, what are you willing to do about it? What are you capable of doing about it? Now, you asked me to give you the information from what I see from the last email you sent me here. If you go to the blog site that I gave you, the toweroflaw.wordpress.com, and you look at that red light camera article, down at the bottom of that article are all of the documents attached to that lawsuit, including the original filing by the law firm. All of their contact information is in that document.
Oh, that's kind of interesting because I look at that, and it appears to be from Houston. Maybe I'm looking at the wrong one, but it was a Houston.
No, well, if it's in Houston, well, wait a minute. There are two different firms there. Okay, Houston was the ones that issued the ticket, if I'm not mistaken. They issued a red light camera citation to a car belonging to a man in Louisiana who hadn't even been here. And Houston issued the ticket. But the law firm he hired to fight the ticket and file the lawsuit, I'm pretty sure was in either Plano or Fort Worth.
Yeah, I didn't see that one. The only one I saw was the guy versus Allen City. And the law firm was out of Houston, and I called the Houston law firm, and the young lady, they didn't recognize her.
So recognize her?
Yeah, they said that she wasn't on their list.
Okay. Somewhere we're not having a connection here on where this is. Hang on just a second. Because I'm pretty sure that, let's see.
You recognize that block? It's called Block and something, LLP.
All right, let's see. That's the city attorney representation letter. All right. The city attorney, this was Crossfield. This was Elgin. And Yeah, that's the representation letter. The actual plaintiff's notice of filing suit. Irving, Texas. The law firm is Bowman and Stella PC, Irving, Texas.
Bowman.
Okay, their number is 214-922-0220.
922-20.
922-0220. Area code 214.
Got it. Thank you.
Mm-hmm.
I will make sure I'll give them a call first thing in the morning. And should I turn in this document or don't sign it, just let it go?
No, you're going to need that for them. They're going to want you to send them everything. If they agree to see you or talk to you or take a case for you, they're going to want that. So make sure everything that you've gotten from anyone in relation to this, you get it organized and ready to send over to them however you need to. All right, hang on just a second, and we'll pick this up on the other side, okay? We'll be right back, folks.
This is the Logos Radio Network.
Ain't gonna blind me. Don't fool me. Well, ain't gonna fool me with that same old trick again. I was blindsided, but now I can see your plan. You put the fear in my pockets, took the money from my hand. Ain't gonna fool me with that same old trick again.
All right, folks, we are back. This is Rule of Law Radio. All right, and we are talking with Donald. All right, Donald, go ahead.
So the guy, was telling me I had no defense, and he was going to set it up for appeal. And,
well, first off, let me ask you this. What did you say to him? Tell him whatever.
He asked me, was the vehicle that he was showing me on the video, was I the owner? And I shared with him I was not the owner. And he looked at me funny. He said, well, who's the owner of that vehicle? I told him the state of Texas. He looked at me funny again. He said, what do you mean by that? I said, the state of Texas is the title holder. They're the owner. And he said, okay, are you the registered owner? And I said, part. He says, well, who's the other owner? I said, the state of Texas. He says, well, what do you mean by that? I said, I just have a certificate. They have the original title. So I'm not the owner of the vehicle. I'm part owner. He says, okay, then answer me this. Do you pay registration once a year? I said, yes. He says, well, you're the owner, you're the registered owner. And I said, no, I'm part registered owner. He says, do you have a driver's license? I said, yes. He said, can I see it? I said, sure. He said, you see your signature down here? That signature says that you will uphold all the transportation laws based off of that signature on your driver's license. So you're bound by the transportation laws of the state of Texas.
He forgot one little caveat to that, see? You are only bound by the transportation laws if and when you are using that license to engage in transportation. Having the license alone is not evidence of, nor intent to, engage in transportation. It means you can if you wish, because your documentation is in place for that purpose. But that is not evidence that you are doing so. Any more than having a hunting license or a fishing license is evidence that you are hunting or fishing because you buy meat in the freezer at the grocery store.
True.
Okay?
True.
This is why idiots are not allowed to make conclusions of law. Okay?
And then he said, well, I told him, I said, that's not true. I said, I'm not consenting.
Okay, the problem is, though, here's the problem, Donald. You are talking. Okay? You shouldn't be doing that. Why are you talking to him in the first place? See, here's the thing.
Up here.
Okay, officer, you're asking me all these questions. Do you have any evidence in support of your conclusion that I am the one responsible for running this light? Well, you own the car. Objection. Non-responsive. Does not answer my question. Do you have any evidence that I am the one that ran this light? Well, if you weren't, who did? Officer, again, non-responsive. Do you have any evidence that I am the one that ran this light? You see how this works? We don't get into discussions with them. We do not tell them where they're screwing up or how they're screwing up because that gives them too many opportunities to make a way around it.
Let's see.
Okay? So instead of going that route, protect your rights, okay? Protect your rights. Stop talking. Okay? I don't know why I can't get people to do that. It's like they think this is some sort of game that they can win, and it isn't. You are not trained in investigatory techniques. That cop is. That cop is trained to ask questions that will get the answers he wants, right or wrong. Okay? Don't do that. In any case, I'm assuming that he wrote up that you have a finding of liability.
That's correct.
Okay.
That's correct. And also, that's what that form says. You must submit this form before the 31st day after a finding about liability.
Yeah, the problem is that you're not, as I said, you're not going to get a judicial determination of anything. This red light camera scam is exactly that, a scam. It is an unconstitutional bill of pains and penalties without judicial review. That is the key factor. Nothing in this ever goes through judicial review. Nothing. That alone makes it unconstitutional. Now, that's one thing that lawsuit never bothers to raise, is calling it a bill of pains and penalties. But that's exactly what it is. If me and this attorney's firm could have a long discussion about the transportation code, I guarantee you their lawsuit would have a hell of a lot more in it than this one does.
That's good.
Because I could open their eyes to things they're not even considering.
Okay. Because I noticed that I lost my train of thought. I told the guy that I was reserving my right.
Not if you're talking, you're not. That's the problem.
I wanted the record. I told him the record. I wanted the record to reflect I'm reserving my right.
There is no record. You're talking to a moron. There is no record.
Well, he gave me notes, and he made notes.
But you don't control what he does with those notes or what he writes in them.
Oh, yes, I did, because he gave me a copy. I made him give me a copy of them.
And?
Then I got a copy.
And what good are they going to do you?
Well, I mean, it tells me how he determined that I had no defense to whoever I'm supposed to see next.
I just told you who you're going to see next.
Yeah.
You're going to see a crooked municipal judge that's going to haul you right over the coals along with her cop buddy or his cop buddy. That's exactly who you're going to see. Cooperative theft.
Well, hopefully when I call the law firm, they got enough savvy to do this. If not, I'll tell them to give you a call so you can help them.
Well, they have enough savvy to do what they did in the lawsuit. But all I'm saying is there is a lot of stuff they obviously either don't care about or don't know about that could have gone into that suit as well. That would have made it an open shut case of extortion and fraud.
So would I be able to open up a new one?
Well, I don't know. I don't know if they can add you to the one they have as another plaintiff. I don't know if they'd have to do one individually for you. I don't know. I don't know what their docket is. So.
Well, if they do open up a new one on my behalf, then I'll make sure that they consult you because I don't want the same version.
Well, the first thing they're going to ask you is this guy an attorney? Is he a law professor? Is he any of this? And once you tell them no, which would be true, they're not going to want to talk to me. And I don't mean they won't necessarily, but it'll be hard-pressed to do this. But now you can tell them this. The Texas Municipal League and the Texas Municipal Education Commission tried to get me to come to Houston to do a presentation on all of these issues relating to the Code of Criminal Procedure and the Transportation Code to the same attorneys and municipal judges and JPs that are screwing people over with them. And I know the reason they invited me to do that was to see if they could come up with a defense against it. And that's the reason I didn't go, because I knew what they were attempting to do.
Right. Okay. That's smart. Okay.
All right. So you feel free to talk to them. If they're willing to talk to me, that's fine. Shoot me an email. I'll give you my contact information by phone, and I'll be happy to chat with them.
Cool.
All right.
I'm going to make it mandatory.
Okay. All right. Well, anything else?
Hey,
All right, well, then hang on, and we'll cover that on the other side. I got a break coming up. All right, folks, we'll be right back. 512-646-1984.
Having trouble breathing? You might want to reach for a bitter-tasting substance like grapefruit peel and take a big whiff. I'm Dr. Catherine Albrecht, and in a moment I'll tell you how bitter foods could be traditional inhalers for opening blocked air passages.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Bitter foods may soon give pharmaceutical inhalers a run for their money. Researchers have found that inhaling bitter substances opens bronchial airways better than any known asthma medication on the market. Apparently, the bitter taste receptors we have on our tongues are also present in our lungs. If something tastes bitter in your mouth, the receptors in your lungs will pick up the bitter scent molecules too. The lungs react by opening up the airways. Scientists are experimenting with aerosols made of bitter substances like quinine, the ingredient that gives tonic water its bite. They believe this could help bring relief to millions of people suffering with bronchitis, emphysema, and asthma. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Trails.
You're listening to the Logos Radio Network at logosradionetwork.com.
Yeah, who you want to chip? Who you take me for? Free toilet? Who you want chip? Me no free toilet. You can't chip me. How am I saying? Don't let them chip you in the morning, chip you in the evening, put a chip in your body. And then when you go computer ready, you can't hide me from nobody. When me say, chip in your mom, chip in your daddy, chip in your grandpa and the grandme.
All right, folks, we are back. This is Rule of Law Radio. We got a half an hour left in the show, 512-646-1984. And we are talking to Donald in Fort Worth. All right, Donald, what was that last thing you were getting into there?
Well, the last thing was just to tell you thank you, and I'll let you talk to the next guest.
All right, sir. Thank you very much for calling in, and good luck tomorrow.
Thank you.
Yes, sir. Bye-bye. All right. Now we have Truth Raider in Oregon. Raider, what can we do for you?
Good evening, Eddie. Thank you very much. Folks out there, I'm a believer that this works. I just used the steps to challenge in court, and sure enough, it stopped them in their tracks.
The steps to challenge in court being when it's a civil infraction issue, correct?
Correct, yeah. You were telling me if it's a civil issue, then it's a little easier than trying to fight their charges for attempting to charge me with crime or misdemeanor or anything.
Correct.
To the piece.
Because the initial stop to write you the citation in a civil infraction is illegal. There is no probable cause. There is no reasonable suspicion. Therefore, there can be no probable cause to make a stop and seizure of a person or their car. Everything they discover becomes illegally obtained information and evidence, which can be suppressed under the fruit of the poison tree doctrine.
Right. This is what I did. I went in there and I said those very things to a clerk requesting that I would like to have the traffic tickets dismissed at the traffic court. Now, the traffic court is separate from this last one, which was the circuit court, which was the case where they were trying to charge me with not presenting an ID to a police officer. So it was part of that same traffic stop, all inclusive in the same traffic stop for the two alleged violations of driving while uninsured and driving without a license.
Right.
And then the third, So they said, well, this is what you have to do, and I'm paraphrasing the clerk. You have to pretty much write a really nice letter to the traffic commissioner. I guess that's what.
Do we write letters to anyone, Raider?
If anything's done, it's going to be certified, and it's going to be.
No, you're not answering my question. Do we write letters in cases? Well, that's the reason why I want to call you first. I don't know if that is the correct way to go or not. No, it's a motion to dismiss, always. We treat everything as a court proceeding. We do motions to dismiss. How can this person she's talking about offer you any relief?
When I asked them, is I want to get these two tickets dismissed. Well, you have to write a letter to her requesting to see her in her courtroom in order to discuss that matter.
Whose courtroom?
This particular traffic commissioner that I went to see in January concerning the traffic charges.
Okay. Well, right there, you've got your information. A traffic commissioner, not a judge.
Right. Exactly. So I have to write something and give them something, correct?
Yes, it's a motion to dismiss.
Right. So I just write in there, I request or do I demand a motion to dismiss?
I move for a dismissal of all charges on the following grounds. And then you state the grounds, and pursuant the Supreme Court ruling in the such and such cases, fruit of the poison tree doctrine, the initial arrest and seizure was illegal. No probable cause, no reasonable suspicion. Civil infractions are not crimes.
Okay.
I thought you won this already. Why are you asking me how to do this if you've already done this?
Well, this is concerning the traffic charges that they convicted me of in January. The one that I got dismissed was the so-called criminal charge of not presenting a license to a police officer when requested. It was the same stop, though. All part of the same traffic stop. And as you said last week, anything in that traffic stop is all-inclusive and subsequent to dismissal as well.
Yeah, they never had original jurisdiction. That's their key thing right there. No original jurisdiction, no crime. The initial stop and arrest was illegal. Well, you weren't arrested, you were detained. Objection. Detained for a civil infraction, which is also illegal.
Well, he stated clearly under duress, I complied and stepped out of my pickup truck, turned around, put my hands behind my back, and put me in handcuffs and said, "You are under arrest for driving while suspended." That's his very words.
Okay, that's still not the issue here. He stopped you under false pretenses. He had no authority to stop you for the initial infraction.
Correct. So that's what they want me to do. So I'll do that tomorrow. I'll go in and say I'm requesting a dismissal of all charges.
No, I'm not requesting. I am moving for a dismissal of all charges.
Okay, moving is the key word.
Correct.
To dismiss. Okay.
Except you say move, not moving. I hereby move that all charges be dismissed and blah, blah, blah.
Okay, hereby move is proper semantics to use. Okay. Now, in your seminar material packet, which I'm planning on purchasing, does it have all the other forms or the requirement or the necessary forms?
There's nothing in there dealing with civil infractions, but there is an example of how to write one, or at least the information it has to contain, on my blog site.
Okay. Because the next step after that is to go back to that circuit court and try to file, I guess, what is it called? You've been discussing with another caller called Title 42.
That's a civil law. That's a federal lawsuit. Yeah.
Federal lawsuit. Okay. So do I start with a state lawsuit, state and county lawsuit first, or do I?
You can sue in both of them at the same time if you can afford to file in both of them. But if you sue in the Fed and not the state, you will not get to go back to the state.
Okay. So what's the best course of action? Move to file it against the state?
Again, I don't know because I don't know what your financial situation with it is. You're going to have to pay the filing fee at either one of them unless you get a declared indigent to do it.
Yes, I'm working on the Informa Pauperis of Oregon waiver. Okay, so I'm going to start with the state first. And my question is, how would I word that? How would I...
If you need to know how to write a lawsuit, Raider, you're going to need jurisdictionary. I can't tell you how to write a suit in 10 minutes on air.
Okay, good. All right, jurisdictionary. So
now remember, jurisdictionary teaches you how to do lawsuits. It does not teach you how to do a Title 42. Title 42 is a different animal. It's similar, but it isn't the same. Like I told the caller earlier, you need to read Title 42 lawsuits that won, so you'll know how to write one properly. Don't write or read just anyone that was filed, because they may not state their causes properly and may have been dismissed. You need one that won. And it needs to be as similar to your issues as possible so that you can mimic it as much as possible.
Correct. I want to be able to use... it's very key to have everything correct, or they'll have any excuse at all to throw out the case.
Yes, they will. In any case, the information that's relevant to doing what you need to do is in the article, Things to Know About Civil Infractions if your state has them, on my blog site, taooflaw.wordpress.com, TAOOFLAW.wordpress.com.
WordPress.com. Got that information down. So we start off with jurisdictionary. Now, that's the Michael Mears' program, correct?
No, that's Dr. Grant. or Graves, I'm sorry, Dr. Graves' jurisdiction area, the 30-year attorney out of Florida.
Okay, Dr. Graves. And he's pretty thorough. He covers everything you approve of.
Everything except how to actually sue a government official. It doesn't cover how to avoid 12b6 dismissals in government cases, and it doesn't deal with 1982 specifically. So that's why you need to research those separately from that.
Okay. So.
All right, can you handle it from there, or do I have to deal more on the other side?
No, I think I'm pretty good there. So,
all right, folks, we'll be right back. All right, folks, we are back. This is Rule of Law Radio, and we are now in the last segment of the Monday night show, and I hope so far everything's gone as everyone's expected. All right, we have Doug in Wisconsin. Doug, what can we do for you?
Yes, I called last week and got a pullover by State Patrol for a loud muffler.
Uh-huh.
Ended up going through the your script kind of, and ended up with a no insurance ticket. You asked me to look up the statutes and send them to you and call in today. So
did you send them to me?
Yes.
Okay.
I do have them in front of me as well. So.
And what email address did you send them to me under?
Idiot Rule of Law.
No, not my address, yours.
Oh, I'm sorry.
Just give me the first part of it. Say again?
SPNP.
Okay, I got it. Never mind. You don't have to give me the whole thing. I don't want to publicize it for you. Let's see. Okay. Yeah, I read this already. Okay. All right. So what's your question?
Well, I asked how to proceed last week, and you asked me to read statutes and get back with you. And basically, that we know that the stop to begin with and everything afterwards was through the poison tree, so to speak, because the initial stop was unlawful to begin with. That's kind of where we were going. And you asked me to do a motion for discovery for the tapes, which I did a couple days after we talked. So I guess I have a date, about 3 weeks. So I'm wondering, I guess the scenario, if I get the tapes or if I don't, how I should proceed before the court date.
Well, this set of statutes was originally enacted under the 1983 Senate Bill 604, 1983 Wisconsin Act 243, April 20th and 26th of 1984. That's your original amendment to the statute. It's not the original law that the statute is based on. So you need to do the research backtracking this.
Okay.
Okay, the problem is I don't see information within this bill that gives us the back direction for the original law. So you're going to have to figure out how to research that and find it, which means you're probably going to need a law library.
And it'll probably say something to the effect of make it obvious that it wasn't to be applied the way it was applied. That's what you're getting at.
It's
right?
Possible. The actual purpose of the law will determine what the application of the statute is.
Okay.
347.39. Let's see. 10, 11. Yeah, you're going to need to backtrack that further than what this is going to give us here. Let's see. The first thing is, what is a person defined as? What is operate defined as? What is highway defined as? What is motor vehicle subject to registration mean? See, that's the thing. When it says motor vehicle subject to registration, that tells you right there that there must be some that are not required to be registered. Why? And the reason is because they're not subject to this statute. And the reason they're not is because they're not in the subject matter to which the statute applies. because they're not in the subject matter to which the actual law applies. You've got to find out what that subject matter is.
So let's just assume...
no, let's not assume anything. Never do that.
Yeah, but for the sake of the phone call here, can we assume one of the scenarios is that this does not apply to myself? Now, how would I...
There is the possibility that it does not apply to anyone except those engaged in some form of commercial use of the highways.
And in which case you would enter a motion to dismiss based on that?
Absolutely. Lack of jurisdiction. If the subject matter does not exist, subject matter and in personam jurisdiction does not exist. Therefore, jurisdiction at all does not exist. See, the two jurisdictions they cannot live without, subject matter and personal. They have to have jurisdiction over the subject matter. Well, if the subject matter they're claiming jurisdiction over is operating a motor vehicle with a loud muffler, and yet that subject matter under which that sits is transportation, then without proving transportation, they can't prove the underlying subject matter because it's completely dependent upon the existence of transportation to exist at all.
You also asked me to request tapes from the law enforcement agency as well as the...
If you're going to use them in court, yes. But until you know what you're using them for, you don't know if they're going to help you or not.
Well, the thing is, I won't be able to talk to you for another week is why I'm doing some hypotheticals.
Well, the thing about it is, your argument is not going to be what's in the videos. Your argument is going to be that they were attempting to apply a statute to you that doesn't apply to you because you're not engaged in the regulated activity that the statute and the underlying law apply to.
Couldn't a person just do put into the record a certified copy of the original legislative intent law that basically says what we're talking about right now, and then they'd see that this person knows a little bit. We don't want to bother with them, so we'll dismiss it.
You're asking me to tell you what they might do. The answer to your question is maybe that would, maybe that wouldn't. You don't know. They may decide to see how much you do know and if you know how to use what you think you know. There's no way to tell what they're going to do. That's why you better know what to do regardless.
Mm-hmm.
What you need to do is get a certified copy of the original bill's caption or title, whatever it's called in your state, okay? And the constitutional sections that says that caption or title must contain the subject matter, that a bill can only deal with one subject at a time, and here's what that subject is. And everything they're doing under the code must relate to that subject matter, which means they must allege and prove the existence of that subject matter. And if they fail to do that, then it's impossible to prove the underlying offense. Because the underlying offense cannot be committed without the subject matter itself being an issue, an elemental issue.
Okay, so you asked me to get the tapes, but apparently the tapes aren't the big...
No. It depends on what you're attempting to do. I'm not saying the tapes won't be useful, but it depends upon what argument you're going with and what evidence you're going to produce as to whether or not they will. If for nothing else, they may be good for you to use to sue somebody. But they may not necessarily help you in this case if you can find the information we're talking about.
One more thing really quickly is that the county said that only the law enforcement agency would be able to produce that, but you said that they have separate possible.
That's correct.
Tapes.
Whoever the law enforcement agency is that did the recording is going to be who has it. Who did you ask for it from, or were you planning on asking for it from?
The court where I'd appear, and also the...
You can't ask for it from the court because the court wouldn't have it. The court is not the custodian of record.
The district attorney or the prosecutor?
The district attorney may not plan on using it. Therefore, he wouldn't have it necessarily either.
Well, I'm just mentioning what you asked me to get it from.
No. I asked you to get information from him as to what evidence he intends to use against you in this case, because you have a right to see and or obtain copies of any of that evidence, whatever it may be. He may have the video. He may not have the video. But from him, you're going to have to get it through discovery. You may have to get it through discovery from the police agency. But you are also generally able to get that stuff through a public information request as well from the agency. But whoever produced it is generally the one that is the custodian of record for it. That will be the law enforcement agency, not the DA, not the county attorney, not the court, not the county itself, the law enforcement agency.
Real quickly, if you weren't able to get this in time before the court date, what would you do? Try to get an extension or something?
You file a motion for an extension of time or a continuance, yes.
Okay, I'll let the next person come on.
We're out of time. There is no next person.
Oh.
All right. All right, Doug, thanks for calling in. Rob, I'm sorry, man. You got on just a little bit too late with the callers I had. Better luck next week, or if you got something more pressing, try to get in with Randy on Thursday or Friday. All right, everybody, I want to thank you so much for calling in, for listening in, for helping us out with the finances and stuff. Please, whenever you can, whatever you can. We're desperate for survival around here on funds, always are. So please give us a hand where you can. I want to thank you all for being out there and supporting us to the best of your ability and for listening into this show, and thank you for making it the popular show that it is. I really appreciate that. All right, folks, y'all have a great week. Good night, and God bless. Dangerous.